Good morning, everyone. So we'll get started on this chapter, which is going to be business methods, patents, and trade secrets. So what we'll discuss today is a different type of intellectual property that belongs to a company, which we call as methods, patents, and also trade secrets. I'm sure you understand every organization that we are aware of have certain business methods that they want to keep them towards themselves, own them as proprietary. They do not want competition to just copy them. And they have also certain trade secrets which they want to keep for themselves because that gives them a unique position in the market space, gets them that kind of advantage, competitive advantage with customers and with the market as well. So these are definitely intellectual property that we see with businesses, and more so in the e-commerce space, in the cyber space, because every organization that we are aware of doesn't only work in a particular physical location, but they also have an online presence and they operate in more than one place through the ability to leverage technology and through their ability to leverage internet as well. And because of which, the chances that these business methods, patents, and trade secrets get stolen, can get copied elsewhere, just loses, it'll make the business lose their competitive advantage that they have taken a long time and effort and resources to build. So, with that introduction, we'll move forward on this particular chapter on business methods, patents, and trade secrets. So the patent system of protection, as we heard from the last few classes that you took with me for internet inventions, is recognized in the US Constitution. We talked about it in great length, how the US Constitution tries to protect any kind of inventions, including internet inventions. Also, the patent system was designed to act as an important incentive for inventors. Suppose I make something that's unique, novel, and new, and that hasn't existed in the literature before. I want my invention or material of originality to be protected. And I don't want somebody else to take it away and claim their own rights to it, because that will disincentivize my ability to invent or create something new and novel. So the patent system is itself designed to act as a strong incentive for anybody who is smart, who is capable of creating something inventive. It's also considered as an important engine for the development and growth of new technologies. Only when you have inventions and when you have new ways of doing things, whether it's a design or it's a new type of manufacturing process, it's a different method of doing business. You want innovation always to happen, and including the growth of new technologies in the space of, say, cyber technologies or information technologies. We want new developments and growth opportunities that are there, and for which any country or any particular industry requires the protection of the patent law in that particular country. We see patents for business processes and software programs, such as one like a click order system on Amazon, micro payment methods by PayPal, online auction software for eBay. I'm not sure how many of you have had a chance to, participate in a bid and an auction on eBay. It's pretty much very quick. It actually pulls up information that it has at the back end, and you get these new quotes and new bids for any product that you're trying to purchase on eBay. So if there is a bidding option open for a particular product, I could put $20. And if somebody else has a $25, then I have to bid another $5 extra. Then I bid 30, somebody bids 35, it goes on till the time actually zeroes out. It times out completely. And then somebody who is at the highest bidder wins the chance to buy that particular product on eBay. So these are possible because of the technologies that are being used. And these are certain business processes that helps these companies like eBay run selling of products so successfully. It gives them a very unique kind of advantage where you have bidders from across the globe participate on the eBay platform while purchasing products of their choice. Some of them need not be new products, they might be antiques, very used and old products, very unique products that are not yet manufactured, that stopped being manufactured, and somebody wants to buy them. I have purchased a lot of collection or collector's items on eBay, participating in auctions. Sometimes I've won an auction, sometimes I don't. But the software, the business processes, the software programs at the back end of eBay auctions are a classical example of a right to be patented because it gives them a very unique kind of advantage. So today's class, we focus here on business methods patents. That is one subclass of utility patents. You have several types of patents, right? And one of the patent types are called utility patents, of which business method patents are one subclass. And they're very highly relevant in the cyber technology or information technology or in the internet space or what we refer to as the e-commerce space. And today's organizations are all in the e-commerce space because they want a wider scope of reaching a larger customer base across the world. And they want to create a revenue stream, not just from the physical location where they can sell, because that'll simply limit their ability to have the reach for customers, their customers able to come to a physical location and purchase a product. But if you're in the e-commerce space, you have access to a wide range of customers across the globe. You could keep your e-commerce website running 24/7. There's no time where an Amazon website or eBay site closes because it's late in the evening, because it's somewhere else, it's in the morning, and people are purchasing products on Amazon and on eBay, and all the websites that you see today. So e-commerce is something that all organizations are familiar with. They have no choice but have their presence on the internet space itself. And they want to make sure if they have a very innovative business method, that it has the protection of the patent law. And in this case, we are actually talking about the business methods patents, which give these companies a strong competitive advantage. So in this session that we are having right now, we examine what business methods are, those that are patentable, and how patent infringement claims are litigated. We'll also talk about trade secrets, another method of protecting digital intellectual property assets, and that are perhaps the least understood and the most used. You guys are all in the internet IT profession, and you're all coming from technology side. Even if you're business major students, you know how important it is to have your digital intellectual property that you have created, which is very inventive, is protected either for your own business or for the business that you work for. Essentially, a trade secret strategy requires any company, any business to be able to maintain that secret. And it's a continuous managerial effort to protect that secret because that secret actually gets them that competitive advantage. You don't want to lose that competitive advantage. If you did so, anybody else, any other company could do the same thing. Customers could have plenty of other options, and you will start losing your own customers. You'll start losing sales and revenue. So the trade secret need not be novel. It can be obvious or useful, and the secret carries on indefinitely, potentially beyond the limited term of the patent protection, as long as your managerial team works really hard in maintaining the secret. That's about the trade secret side of it. Now, patent is the grant of a property right to inventors. We talked about it. Anything that you're creating, which is very inventive, very creative, you get the patent, granted to you because you're an inventor. You created something new, and that right to that particular patent is granted by the U.S. Patent and Trademark Office, and for a period of 20 years from the date on which the application was filed. You know that 20-year term from previous discussions that any of these patents have a protection for a certain period. It is, in a sense, a government-sponsored monopoly. What does this patent grant indicate? That you have absolutely exclusive rights to use it, to control it, and you have a complete control on the subject matter itself. The grant of a patent gives you as an inventor the right to exclude others from making, using, offering for sale, or selling the invention without the right permissions and authorizations. The right to make, use, offer for sale, or sell the invention stays with only you as the patent holder, and that's granted by the U.S. Patent and Trademark Office by filing the right sort of paperwork that's required. So the U.S. Constitution, Section 8, is the source of all patent regulation. That's in the U.S. And definitely in other countries, you have every country has their own specific patent law in force. And if you're, say, operating in China, you must be aware of the Chinese law for patent protection. If you're operating in, say, Brazil or Ecuador, or you're operating from, say, the Dominican obviously you should be more well versed with the patent law in the local country. The European Union has a very robust kind of legislation to protect not just patents, copyrights, trademarks, all kinds of things are better protected in the EU, European Union. But the US law is, being amended from time to time to make it equivalent to the European law so that there is easier trade. And when companies decide to operate from elsewhere, they have the same level of protection for these kind of intellectual property. The Congress has the power to promote the progress of science and useful arts by securing for limited times to authors and inventors these exclusive rights that we called as monopoly to their respective writings and discoveries. And in the process of giving that kind of protection, they're actually incentivizing these inventors, these authors of original work to do more because they have the protection. They can make use of those, exclusive rights for that particular period of time. The primary goal of patent law is to create an incentive. That's what I just said. By conferring that kind of monopoly, the Patent Act is the main patent statute in the US. Whoever invents or discovers any new and useful process, it just doesn't have to be something that's only tangible, even a process, a machine, or a composition of a matter in a unique way. Suppose you're working in the biochemical industry, you're a scientist there, you know how to uniquely combine certain materials. That kind of composition of matter that provides some kind of medical inventions can be also patented, or any new and useful improvement thereof can obtain a patent. Anything that is the natural laws of nature, natural phenomena, any abstract idea, these are not patentable basically. Anything that's pretty obvious because of it's part of nature, anything that's abstract, I might think abstract things. I can fantasize, I can dream, I can visualize certain things, but these are abstract ideas. There's nothing tangible there. There's no process created. There's no machine actually manufactured. There's no unique composition of matter, and nothing useful has been created, or no further improvements have been evidenced. Then I cannot simply patent an abstract idea. It's also important to make a detailed, thorough research. We discussed this in the last class as well, that you have to do your due diligence, a lot of research in utilizing patent as well as non-patent literature to determine whether this subject matter is new, useful, and non-obvious. The issue of non-obviousness is, contested, debated, because you have to ask yourself what is obvious versus what is not obvious. Internet applications could have been easily anticipated. This is like an example. If you're starting a company and you know that your company is going to go towards the direction of e-commerce, then you also are aware that you're going to have internet applications or whatever you're doing in terms of selling your products or services, because you know that there is a direction of going towards the e-commerce platform. That's not an inventive step. That is something that anybody could have anticipated because it's a logical step. You create a business locally, for example, and then you decide, hey, I found an opportunity to go on the internet space and create an e-commerce platform for my business. That's pretty obvious kind of thing. We know that's going to happen at some point of time. This is easily anticipated, and it's something that's pretty obvious. So that these kind of things actually bring up the topic of what is obvious versus what is not so obvious. I just did mention that there are different types of patents. One is called the utility patents, which includes new and useful processes, machines, articles of manufacturing, compositions of matter, or improvements thereof, which are all part of business methods patents that we are discussing in today's class. Apart from the utility patents, which are a subclass of which is business methods patents, there are other types of patents called design patents, which are new original pieces of work, a design of articles that can be manufactured. So anything to do with, say, design elements, like you could design a new style of building, a new design of a machine, or you can have ornaments which have new designs. Any piece of original work which has a design component to it are called, design patents that if you can file for and get a registration from the U.S. Patent Office and Trademarks Office. There are also plant patents, which are inventions, discoveries relating to reproducing any distinct kind of new variety of plants. There's a lot of research going on in that space. And you also have business method patents are the only ones directly related to the discussion for today, because we are interested in discussing internet and e-commerce space. Especially our topic is about cyberspace and the kind of stuff that happens in the cyberspace, where you have hackers, you have companies that are trying to steal your very original and inventive, creative ways of doing business. So the value of a patent depends on several things that include how inventive it is, the patent applications that investors describe exactly what the patent, if issued, would cover in detail. The Patent Act also requires any of the inventors to describe their work in full, clear, concise, and exact terms. So if you created something new and you think it is new, and you are seeking patent protection, you are required to describe your work in full, clear, concise terms. And that's a requirement by the Patent Act. A patent agent and an attorney who can help you can state in the application clear statements of the invention, and what are the claims that you're asking for? What parts of that particular invention are you claiming that you should have a patent issued on your name? You, as a party that is applying for the patent, can also restate the claims in an effort to narrow or reduce the number of claims that the patent holder can ultimately control. You don't control everything out there. You only control whatever little portion that you have created, something that's new, that's not obvious, and that's also useful. And that's very inventive and creative. You can only claim control only on those little components. You cannot claim control on the whole ecosystem that's already out there. So that's about the process in terms of which you hire an agent and an attorney. You do the proper paperwork. You have to make a description on your behalf as well. And the attorney also can put statements and claims of what are patentable material that you claim that you have and you're applying for. There's a two ways of looking at how patent filing happens and the grant of patents themselves. First to invent versus first to file a patent. This issue arises when two inventors file a patent on the same invention at the same time. Under the first to invent system, the one who invented the process earliest wins. That's one way of looking at it. Anybody who is the first to invent will be granted the patent. Under the first file system, the one who files the earliest wins. So every country has their own way of granting patents under their patent law. And the first to invent system, actually, they use the premise that whoever invented the process first wins the case and gets the registration to the patents itself. In some countries where the first file system is used, whoever files the registration papers with their local patent offices, they win the patent themselves. The U.S. Patent Office, since its inception more than 200 years ago, works on the first to invent system. So under this system, if you're an inventor, you don't have to be the first to file for patents. You just have to keep a record of the inventions that you're working on. You can make progress, you can refine it, you can go back and make it even better. You can make sure that the invention is really mature, it is safe and robust in terms of the use case scenarios, adoption of new technologies, and stuff like that. So you just have to keep a log, a record of your invention and all the progress that you've made, because you're the first to invent. You don't have to be the first to file. And that's in the US. All of this is done before filing the patent. The system, by its nature, favors inventors, inventiveness, and innovation, because they're saying, hey, you just have to make sure you have a log, you have a record of your invention and all the kinds of improvements that you're making to it. We don't want to rush you through to filing first. We want to encourage you to be as inventive, as innovative as possible. That's in the US. Now we can move on to the patentability of software. There's an overlap between patent and copyright. Last class, I was talking about copyrights. So there is a kind of overlap, especially when it comes to software. Now, software programs consist of both language and function. So you have on one side the source code, and it can get the copyright protection. But then if it produces something using that code, if your software actually produces a new, useful, non-obvious result, it ends up increasing our customer base, it increases our sales. The source code has been used, the software has been used to result in something that's very unique and non-obvious, then it becomes a patentable subject matter. So the code itself is copyright protected, but if the software used, the application of this particular software is resulting in something that's unique, that's non-obvious, and that's very useful, it becomes a patentable subject matter. There's another example here down at the last bullet you see there. By patenting some stuff like DNA code of living organisms and living animals with engineered genetic codes, the range of patentable subject matter is perhaps exceeding the public good. And obviously, in such cases, the Congress, the government can come into picture and say, hey, this cannot be patent protected because maybe by doing so, you're hurting the good for the public itself, you're harming the society. So that is where the Congress or the local governments can come into picture and say, you can't protect certain kinds of codes, especially something to do with, say, DNA coding of living organisms, because that might inhibit other areas like medicine, understanding of diseases, and stuff like that. But in the case of software, two things are there. This code itself, which gets copyright protected, the functionality, the application of the software resulting in some unique results for the business, that also can get patented as business methods patents. So there are two aspects of it. The copyright protection for the code and the business methods patent protection for some application of software. That's where we are talking of patentability of business methods. The business methods patents are considered to include any process involving data processing, calculations, conversions, and so on used for business operations. Could include software that you're using that results in process improvements, that improves your cost controlling ways of doing things, improves your sales, improves revenue generation, anything of that nature, which is not obvious, which does not exist before, can be patent protected under the business methods patents. The Supreme Court has identified three categories of subject matter that are unpatentable. We talked about it briefly in the last slide: laws of nature, natural phenomena, abstract ideas. Those cannot be patented. Of particular relevance is the mathematical algorithms that are not patentable subject matter to the extent they are merely abstract ideas. So if you use an algorithm to write a particular software code and make it work the way you want it to work, that could possibly get copyright protected and the patent protection as well. But then if it's a mere abstract idea, I just created a theory, using a mathematical algorithm, probably it's not going to be getting the patent protection. To be patentable, an algorithm, as I just mentioned, must be applied in a useful way. Some kind of data transformation should have happened with a series of calculations or different ways of classification of data. Say if that calculation result in a smooth waveform display on a monitor, fractals and stuff like that, then it's a practical application. And in such a case, an algorithm can be patented. But if it doesn't result in an application which is useful, and if it just is an abstract idea, such an algorithm, a mathematical algorithm of that nature, cannot be patented. Now, remedies. What if in case you have a patent infringement? The patent infringement law is civil and there are no criminal provisions, as there are for other three types of intellectual property that we discussed in prior sessions. If you're a complainant because there is a patent infringement, you perceive there is somebody is infringing your monopoly or exclusive rights of whatever patent registration that you have secured from the patent office, then you can file in a complaint. And the remedies are the most important remedies that can be given by the courts, because they can assign you the patents, rewrite inventorship. If they found that you have to have the inventorship, they can put it on your name. And they can also prevent, the courts can also prevent violations of any rights secured by the patent itself. Damages, if you're filing a complaint, you're filing a legal a lawsuit, then you're entitled to at least the amount of whatever reasonable royalty that you should have got, plus the interest and costs, and also any kind of loss or profits if they can be proven. If you've lost something in terms of business sales or revenue or profits, if you can prove that you've lost a certain X number of dollars, then the defendant has to make good that particular loss. Courts may also increase by 3 times this amount for cases of willful infringement. If it's not an innocent kind of infringement, but it's pretty willful infringement, the punishment to the defendant, if proven guilty, can be increased 3 times as well. Attorney fees, and if you're a successful plaintiff, you're a complainant, then you're entitled in exceptional cases even to a reasonable attorney fee, because everything in the US is pretty litigious and attorney fees are exorbitant. And if you've had to spend a ton of money fighting your case because you perceive an infringement, if you win the case, in certain cases, the court can actually order the defendant to pay even the attorney fee. So these are the broad set of remedies that you can have in events of infringement of your patents. If you have any questions, I'll be happy to take them, or else we can have presentations done that we did not have last.